Hello everyone, welcome back. This is Subathra Mylsamy, partner at AK Mylsamy and Associates. So today's topic is going to be on Hindu women's property rights. For centuries together, women have fought for their own rights as well as for the rights of their property throughout the world. And especially in India, if you see, the Hindu property laws have gone through a lot of changes and a lot of amendments have come into place, placing women also on par with men and also to have an equal hand in the property of her own inheritance. So the Hindu women's property rights in India are first governed by the Hindu Succession Act of 1956, and the Hindu widows' property rights are specifically dealt under the Hindu Women's Right of Property Act of 1937. However, it did not address the problems of women's property rights as a whole, nor did it grant the Hindu woman her Copassenary rights. So in order to bridge this gap, in 2005 an amendment was passed and under the Hindu Succession Act, and the significant changes was brought into the act as such. So first let's look into what is actually a Copassenary property and how it was dwelled in the 1956 Act as such. So any intestate or ancestral property which has been acquired by the members of the Hindu undivided family, it is referred to as the Copassenary, or in short it is called as the HUF. So the only three male lineal descendants are have the right to get the property. So under this, if you see, it is the son, the grandson and the great-grandson. So under the 1956 Act as such, women were not considered as co-partners and they didn't have the right to inherit the property. So the 2005 amendment, which was brought into the Hindu Succession Act of 1956, clearly took away the discrimination between a daughter and the son. So the Act here now clearly states that the Copassenary property, the daughter as well as the son have equal rights and can inherit the property equally. So the daughters and the sons under the Copassenary property have equal rights and liabilities. So the most often asked question is, do women have full ownership of the property? So under section 14 of the Hindu Succession Act, every Hindu woman has complete ownership of a property, either movable or immovable, which she has acquired through acquisition. So she may have acquired before or after her marriage in any of the following ways the property. One is through inheritance, second is through partition, or in case in lieu of any maintenance or its arrears, or it can be as a gift from any relative or non-relative. It can be a self-acquired property. It can be on purchase or prescription, as well as it can be as a sidana. So another important feature to be noticed here is the Act gives any Hindu woman the right to freely use the property the way she wants. Especially there is no consent required from her father or her husband on the usage of the property. So she can freely either transfer the property or make a sale of the property and wish to use it according to her needs. So any Hindu woman has the legal right under this Act to sell her belongings either through intestate. When you say intestate is if you receive the property without a will, it will dwell upon you, as well as if you have it is a testamentary property, which is a will is written and given handed down to you. Previously, only Hindu men were allowed to make a will to dispose of the property, but today, thanks to the 2005 amendment, that even women are allowed to make the will as they would like to. So now the next question is, so what is the woman's right over her father or a husband or a son's property? Like I mentioned before, if a woman inherits a property either through a will or if it is intestate, she has all the right to do what she wants with the property. So if you look into the order of whether if she is a daughter, whether if she is a widow or if she is a mother, she has all the right to inherit the property. So that inheritance is in respect to the intestate father, son, or the husbands. So a sister who is a class 2 heir will get the property only when the brother's class 1 heirs are not present. So moreover, a daughter's rights in her father's property is not affected by her marriage at any cost. So she has an equal right in the property as much as her son has in the property. So after a divorced woman is entitled to maintenance or an alimony from her ex-husband. So under the Hindu Succession Act, the devolution of property is divided into class 1 heirs, class 2 heirs, agnates and cognates. Now the class 1 and class 2 heirs is a long list which is very easily accessible if you look into the Hindu Succession Act as such. I would like to explain to you who is an agnate and who is a cognate here. So who is an agnate? If a Hindu male dies intestate without writing a will and does not have any class 1 or class 2 heirs, then the property goes to an agnate. Now agnate is any male who is related by blood and or is adopted, and it does not include relationship by marriage, and also it does not include widows of lineal descendant. Now who are these cognates? Now any Hindu male who passes away intestate, the same thing without writing a will, and does not have any class 1 or class 2 heirs, then the property goes to the cognate. So the cognate here is related to the intestate person by blood or by adoption, but not wholly through the male. Here even a woman can be part of it. So for example, it can be the mother's brother's son, or it can be the brother's daughter's sons. So another important question which is often asked is what happens to a woman's property if she dies intestate, which is if she dies without writing a will. So section 15 of the Hindu Succession Act clearly brings forth how the property has to devolve under certain circumstances. First, upon the sons and daughters, which includes the children of any predeceased son or daughter and the husband. Secondly, it falls upon the heirs of the husband. Thirdly, it goes to the mother and the father of the woman. Fourthly, upon the heirs of the father. And lastly, upon the heirs of the mother. So to sum it up, section 15 of the Hindu Succession Act clearly elucidates that daughters, mothers, and the husbands have the rights over the property of the intestate mothers, daughters, and wives respectively. So I would like to conclude saying that women have come a long way and have also established their rights in several areas. Same way, I think under the Hindu Succession Act, women are also given an equal footage along with the male. So it is extremely essential for us to know our rights and how we can use it in the right way. I hope you have enjoyed this video. Thank you so much for watching and see you until next time. Bye.